All right, welcome everybody. I'm excited. I have Linda back on the show. Linda SHAO, also Yitai SHAO, is an attorney in California. Attorney Yitai SHAO is licensed to practice law for now 21 years in California. Attorney SHAO obtained a bachelor's of law from the National Taiwan University, a JD from the University of Iowa Law School, and an LLM from Washington University, St. Louis. She had several media appearances because of her history of her outstanding advocacy in criminal defense and a very famous civil trial in San Francisco court. Linda, welcome back.
Thank you.
All right, so I want to talk about this, and we have been talking about your cases for the last 2 or 3 interviews. And before we get started on today's show, I really wanted to maybe have you give us a recap of the cases that are before us, before the courts, and what is happening. So why don't you kind of give us an update as to what's going on?
Yes, let me give you a summary, please. And there are 3 cases I filed with the Supreme Court since July 2017. The first one is 17-82. The second one is 17-256. And the current one is 17-613. The one which will be heard this Friday, February 23rd, 2018, is 17-613. And what the cases are about? These cases are all about the only one issue is lack of impartial court. For the 17-82 and 17-256, these are cases I filed against the same respondents. My prior attorney who represented my family law case after my little child was taken away unlawfully. And this attorney betrayed me and behind my back conspired with the court. I was not aware of their conflict of interest. Because I sued them, so they used the relationship with the court to continue deprive of my child custody without compliance of constitutional due process. They are James McManis, Michael Reedy, in the law firm of McManis Faulkner. And this law firm is so powerful because they are the strong financial supporter of the American in civil court. For example, James McManis is a master of San Francisco Bay Area intellectual property American in civil court. He invited the judge who decided who granted their dismissal, granted their motion to dismiss the underlying case for 17-256. Is their buddy. Judge Lucy Cole is also a master of San Francisco's intellectual property American in the court. And Lucy Cole is also was also in the executive committee with Michael Reedy in the William A. England American in the court. So this relationship caused my unable to proceed any jury trial, unable to proceed with any appeal. So that is the reason why I petitioned all the way to the U.S. Supreme Court. Then the issue in front of the Supreme Court is whether the attorneys and judges who are members of the American in civil court should be required to disclose their relationship, their regular social relationships. When Judge Lucy Cole, for example, when she was also a member of the executive committee with Michael Reedy, one of the respondents, as I just named before, when she was there, they had about 15 meetings a year, at least 40 regular meetings. Is that substantial? That's certainly substantial. And they received awards, gifts, directly or indirectly from these attorneys. These are violations of Rule 5-300 of California Rules of Professional Conduct. And also, for this same relationship, now surprisingly, also was discovered at the Supreme Court justices. There are 8 justices have the similar financial interest. They sponsored 38 clerks of the Supreme Courts who work for them in the past 11 years to obtain approximately an estimated value of $266,000 gift from the American Insular Court. But none of them disclosed. This is only an estimate. There was never any number provided. And on the website of American Insular Court, under the section of Temple Bar Scholarship, they mentioned they provide free accommodation, free abode, free air ticket, and quote, modest, close quote, stipend. How much is the so-called modest stipend? No one knows. But all I the federal law under the section section 620 .35 and .20 requires gift to be not more than $100 a year. So what is the modest means? But whatsoever, no, it's undisputed. This kind of gift is based upon their function as a clerk, as a law clerk, who provides recommendations to the justices about how to rule on a petition for real petition for real certiorari or petition for rehearing. So they have the power to decide the cases. And American Insular Court is nothing less than to provide a huge amount of a gift, more than 1,000 times allowable under the code, to bribe them. So these attorneys, for example, James McManis is also appears with the U.S. Supreme Court. But does that not constitute a conflict of interest? It is, because the attorney who is a strong supporter of the financial American Insular Court, including Temple Bar Scholarship, now appear in front of the court as a respondent, and none of the justices recuse themselves. And so that is the basic issue right now in front of the court. Also includes the issues that will be heard this Friday, February 23rd. That is whether these justices, they should have recused themselves based upon the direct conflict of interest. They fail to rule on that. There is a severe violation of the Constitution, because on every judge and the justices, especially, what the Supreme Court has the constitutional imposed duty to decide, and they fail to decide. And they have a duty to disclose, according to the Guide to Judiciary Policy. It's a code of conduct, and also under Canon 3, they should avoid any ex parte communication. But right now, American Insular Court appears to be corrupt the entire U.S. courts. For example, for their advertisement, which was one of the evidence I presented to the court, and the clerk's office did not allow that to be posted on the website of the court. That this is also irregular, because no court would, throughout the United States, no court will only e-file partial of a pleading. They leave out, and American Insular Court purged the evidence in a video called American Insular Court Member Services. And they talk about, we solicit membership because no organization in the United States you can find to allow ex parte communication. They do not use the ex parte communication, but that means no organization will allow attorneys to be able to communicate with judges in a trial setting. No, they cannot. But now they can, by way of American Insular Court, they can socialize in a social setting. They can have direct email contact with these judges or justices. They can give gifts, awards to these judges, and no one discloses. No one knows how much. And they can influence the judge by way of membership, mentorship, mentor. The justices and judges are mentors for unknown attorneys. They can communicate privately. No one knows what's going on there. These are all violations of Canon 3 A4 to avoid appearance of ex parte communication with attorneys. The judge had the duty to do it, but right now the judges all mess up. And if you take a look at the evidence that they try to purge, and now based upon my criticism, they put it on again, put it back to the YouTube. There is a video called American Inns of Court Member Services. And that one, you can see that the judges, there are several judges of the U.S. Court of Appeal and the other courts. They solicit memberships on behalf of the American Inns of Court. These are all forbidden in section 620.50, if I remember correctly, in the U.S. Guide of the Judiciary. That means the judges are not allowed to solicit membership on behalf of any nonprofit organization. So they cannot do it, but they are doing this right now because they give so much benefits. And the American Inns of Court is using U.S. Supreme Court's site without Congress approval. They use the people's money to hold annual conferences. So U.S. Supreme Court right now is mingled with American Inns of Court. This is a source of corruption. We want the American to have a clean judiciary. We want there's no ex parte communication. We want a clean field. But American Inns of Court right now is providing ex parte communication platforms for the between the judges and attorneys. And U.S. Supreme Court is the head of the entire judiciary of the United States. They shouldn't do it. So these 8 justices who have financial interests with American Inns of Court, without disclosing in the past, they sponsor their clerks to receive such huge amount of financial benefits. They should be impeached to clear up the judiciary of United States, to give us a better United States than before. Thank you.
I like that so very much. I appreciate you bringing this up to speed. I'm going to type this in here: sponsors, clerks of the court. Okay, so this all started with you hiring James McManis as your attorney to help you with your child custody case. Is that correct?
Yeah, that's correct. So yes,
okay.
And I forgot to mention about, I only talk about the 2 cases, 17-82, that's for state case against McManis Faulkner, and another one, 17-256, that is a federal case against McManis Faulkner, and that one was dismissal. The case completely closed out by their buddy, Judge Lucy Cole. And the third one right now is pending with the U.S. Supreme Court, and which will be heard on February 23rd, 2018, this Friday. That is my family court case. And McManis Faulkner misuse their power. They are attorneys representing Santa Clara County Superior Court. Because I sue them, they use their power to influence, to close out my opportunity of my family court case. So 17-613 is about my motion asking the court to remove the venues, that means the court's jurisdiction regarding my case from Santa Clara County Superior Court away from the 6th Appellate District Court of Appeal of California, because they all have clients there. They're justice or judges, they are clients of James McManis. I could not have a fair hearing. I cannot have a fair appeal. As a matter of fact, for the underlying appeal of 17-613, my appeal was already stalled for 4 years. The appeal was from their body, Judge Patricia Lucas' order of November 4, 2013. And this order, I filed the appeal in November 2013. And right now still pending, cannot move on, because Santa Clara County Superior Court refused to allow me to have records on appeal. So I cannot even file any opening brief. It has been stalled.
Okay, wait. So just so everybody who's watching today can understand this, in order for you to make an appeal, you need the records, right?
Yes.
And you're saying that they are not allowing you to have access to the records so you can make the appeal.
They refuse. It's a unit called Appellate unit inside Santa Clara County Superior Court. They refuse to prepare records on appeal. So I can do another way, is by way of filing a motion, and I did that. I filed a motion with the 6th Appellate Court appeal asking to change the designation of records so that I can file myself for the records on appeal. And they also deny. So that means I have no way to have any records on appeal, either from me or from Santa Clara County Superior Court. And Court of Appeal will not order Santa Clara County Appellate Court to prepare records on appeal as well. So that means my appeal right was blocked. My constitutional right to appeal was blocked, interfered by these courts under the conspiracy manipulation of James McManis law firm.
Sure. I want to talk about this because something that that is amazing about this case is you have filed, I believe it was 13 different motions, and you even had another attorney who doesn't work for you. She's a non-interested third party, Attorney Meera Fox, who used a very significant term when she saw all the effort that you're putting into this case, and she saw all the different activity that the courts were doing. She called them shenanigans. Am I right?
Shenanigans, yes. And that is Attorney Meera Fox. You can find her declaration posted on the website of SHAO.chronology.blogspot.com. But let me clarify the 13 motions, how the conspiracy of James McManis and Santa Clara County Superior Court and the Court of Appeal, California courts, were exposed was because they filed 13 motions, not me. For the jury trial of SHAO versus McManis, me against my attorney, that is underlying action of 1782. They filed 13 motions in limine, and they all focus upon the issue that they want to apply collateral estoppel of Judge Patricia Lucas November 4th, 2013's custody deprival order. And as I mentioned earlier, the background, Judge Patricia Lucas is their buddy. Judge Patricia Lucas right now is the presiding judge of Santa Clara County Superior Court. She ruled against me in the custody trial on November 4, 2013. And that order was very suspicious. It appeared to be written by James McManis law firm because it contained 5 pages of recital of the facts, which were not shown in the trial at all. It just appeared. No one did that. No judges would do it. Just recite facts was not proven at the trial. Was not shown at all. Was not discussed. So.
Right.
So these
not only would a judge not recite facts not in evidence, but the other issue is that a judge would not allow an attorney to use those facts since they were not part of the trial. So this is very suspicious activity. And I want to put this up here real quick. This is the Honorable Patricia M. Lucas, judge for Santa Clara County, and you can find her. All you have to do is type in Patricia Lucas, Santa Clara, and you'll find her. Or even if you just type in Judge Patricia Lucas, you'll find her, and she is the presiding judge, Superior Court of Santa Clara County. And so this is very unique. And going back to what Meera Fox said, this is rather strange behavior. She called it shenanigans, and it's really a weird. a weird thing. You don't see that very often. And they filed 13 different motions against you to stop this from going forward.
They filed 13 motions in limine, try to apply Judge Lucas' bizarre order. They try to lock it, but it's pending appeal. So when a case is pending appeal, the decision cannot be applied collateral estoppel. So the next thing they want to do is to what? To dismiss the appeal. But the appeal has been blocked for 4 years and it cannot be moved on. So now they created 4 stockades. They created ghost record, ghost notice, the false notice. They even the James McManis was even powerful enough to use the clerk's resource, ask the clerk to go to the court on Saturday, March 12, 2016, in order to generate a false notice, and then presiding justice of the 6th Appellate Court, Conrad Rushing, Conrad, Rushing, Rushing, and he issued a dismissal of appeal within 25 minutes after the court opening on March 14. That means March 12, on March 11, we had a hearing. March 11, 2016, we had a hearing at the Santa Clara County Superior Court to discuss about the jury trial should be going on. And James McManis attorney said, "Oh no, we want to block the jury trial because we are waiting for the decision of the appeal on Judge Lucas' orders, custody order appeal." Right. And so the next day, within 24 hours, a mysterious notice, a false notice of non-compliance show up, and no court operate the courthouse. Well, I checked with the Betty, what's going on. Betty said, throughout the past 10 years, we never seen any clerk who would go to the court to work on Saturday. But it's a false notice issued on Saturday, March 12, 2016. And then within 24 hours of opening of the court appeal, this presiding judge issued a dismissal. When the law disallowed that, he's required to have a notice, have a motion, and nothing. They just issued dismissal based upon this weird notice issued on Saturday. So Attorney Meera Fox make an analysis, and in paragraph 31 of her declaration, which is posted at SHAO.chronology.blogspot.com, she concluded there's no other interpretation but that there's a conspiracy between James McManis, the Clara County Superior Court, and California 6th Appellate Court presiding justice, Conrad Rushing. So she concluded there's conspiracies. My case has been full of conspiracies from the beginning of a child parental deprival of August 4, 2010 until now. It has been conspiracies. And I think you mentioned about the weird things. This weird thing of creating false stockades, deterring filing, also happened to U.S. Supreme Court. And more egregious is Judge Patricia Lucas. She removed my family courts to be completely disappear from the public access from the court's website, the Santa Clara County Superior Court, when they tried again in 2017, try to dismiss the appeal with false notice. And so this has repeated going on. It's a shenanigan caused by is called by Attorney Fox. This shenanigan continued to U.S. Supreme Court since September 2017, and I discussed that earlier. That includes the Supreme Court also deter filing of amicus curiae motion of mothers of lost children in case of 17-82. They disallow filing.
So, okay, so let's do this real quick. Why don't you give me the substance of this amicus curiae brief that was filed by mothers of lost children? Talk about this and the impact that this would have on a case.
Mothers of lost children talk about 3,000 mothers in California. They were unlawfully deprived of their child custody when they stood up to protect their little children who complained about abuses by their fathers. Okay. And they all got, infirm. They all got sick. 3,000 people, and they all complained of corruption, but they are not like me. I'm an attorney. They do not have my background, and God bless me to got the evidence of corruption. They didn't get it. They suspected with judicial corruptions, and of course there were no investigation whether their attorneys also because of American Intercourt. We don't know, but they complained of judicial corruptions. They lost child custody, and this organization contacted me in 2014 when I filed a civil rights complaint against these judges, seeking to declare. I tried to declare the initial parental deprival to be unconstitutional because these judges, they try to avoid that. No one wants to rule on that. So, but regarding their relationship with American Intercourt, with James McManis, those were discovered only 1 year later in 2015. So mothers of lost children, they were talking about the miserable situation of these protected parents. They lost child custody instead. And Meera Fox told me that she had 4 attorney mothers experience the same trouble I experienced. 2 attorneys successfully overturned. 2 attorney mothers could not, just like my situation, and they suicided. And so their children also suicided as well. So it's a very, this family relationship is really a substantive due process rights. Right. But this due process right have been overlooked and suppressed by many courts throughout the United States. The mothers of lost children, they made demonstration claiming core crimes in family courts annually in Washington, D.C. and San Francisco. But I think they haven't got attention yet. But how this motion was so significant, because usually when there is amicus curiae and there are so many people affected as complained by them, which have similar situation as me, the court should grant certiorari. So they want to deter filing. They deterred once, completely not filed in 1782. And they did file in 17613. That is right now pending with the court.
Okay, so this amicus curiae brief, again, it's sponsored by Mothers of Lost Children. For lack of better terms, I'm using the word sponsor, but it's a motion that was put forth by them. This is an organization that you really had no connection with. They reached out to you because you guys have a similar goal or similar interest, but they don't work for you and you don't work for them. You guys have no financial interest, correct? No, nothing. I don't know any. I only met once during their demonstration in San Francisco. I met the director once. That's it. Okay. And so let's talk about this hearing. It's not a hearing, it's a decision that's going to happen this Friday. Talk about what's happening this Friday.
This Friday will decide my petition for rehearing based upon the courts failed to decide my request for recusal. So I filed a renewed request for recusal as well as a petition for rehearing based upon extraordinary circumstances of violation of due process, that these 8 justices refused to decide on my request for recusal on January 8th, causing the denial of petition for writ of certiorari of 16-613. That is the only case remaining. I want to file a motion to set aside based upon Rule 60B of Federal Code of Civil Procedure regarding 17-256, which is one of the decision they deny on January 8, 2018. But the court supervisor, Jeff Arkin, said, no, if you file that, I will return in writing. Okay, this is in writing that he declined to file. So right now the system, the legislation should change regarding how to handle the situation when extraordinary circumstances exist after the stage of petition for rehearing. Like my case in 17-256 on January 8, 2018, the 8 justices wrongfully denied to vote. They participate a vote to deny 17-256. That is a case where respondents are James McManis and his law firm. James McManis, Michael Reedy, and his law firm. They have conflict of interest, but they participated to deny anyhow because they thought they will clear up the jurisdiction of U.S. Supreme Court. Unfortunately, there's still another case, it's 17-613. So I allege in my request, I request the court to reverse the prior denial because all were unconstitutional. They failed to recuse themselves. They should recuse themselves, and they should not have, the 8 justices should not have participated in any decision of the 3 petitions I filed with the court.
Okay, so let me ask you this. On this Friday, what is it that you would like for the courts to do? What would be the perfect outcome for you Friday?
The perfect outcome is they granted reversal of their orders in January 8th and the other orders they made in 2017 in denying the petitions I filed with the court. There is 3 cases, 17-82, 17-256, and 17-613. That is the perfect situation if they reverse all and to put this motion, certiorari the each of the petition at least regarding the issue whether the judges and attorneys who are related by way of American in civil court should disclose their relationship in the court. So yes. At least they should certiorari that and to return to put the cases revived because they wrongfully, but in violation of the due process, they deny the petitions. And if they didn't do it, to be honest, well, based upon they abdicated their judicial duty on January 1st, 2018, they should have been impeached pursuant to the code of 18 U.S. Code Section 371. That is a conspiracy to disrupt or obstruct a normal function of a court, of a government unit. Let's take a look at the evidence I have been talking about alteration of the dockets.
Okay, so this document that you're about to show us is for what case?
This is 17-613, which will be set for hearing tomorrow morning, February 20th.
Okay, so let's go look at this document right now. Okay, Linda, so I have the document up. Here it is, number 17613. And why don't you walk me through what we're seeing here? What's happening here? We obviously have your name up here, Linda SHAO, the petitioner versus, is that Sung Quinn Wang?
Yes, correct.
And okay, so walk me through what I'm seeing here because I see a docket date of October 24th, 17, and you saying this was altered on 10/25/17 to be June 8th, then changed back to late November of 2017,
And there was a decision date. May I please explain?
Yes, please. Go ahead.
Okay, so that was when the filing date was a mailing date, October 17, 2017. And the docket there was the date the U.S. Clerk's office actually docketed the case into the file of the Supreme Court. On the next day, the next morning, the decision date was changed to June 8, 2017. I was following up with the docketing clerk. I want to find out, I want to chase, to make sure the petition was properly filed. When I called in the morning of October 25th, this is what the docketing clerk told me. He said, Supervising Clerk Jeff Atkins told him to change the date to be June 8, 2017, and stated that it should not be Linda SHAO versus Tan-Kun Wang. It should be another case, Linda SHAO versus McManis Faulkner. And he said to the docketing clerk that the name of James McManis as well as Michael Reedy should not be posted anywhere. And I told him that was wrong. The decision day was April 28th. It's not June 8, 2017. And he said, talk to my supervisor. I cannot handle it. So that was what happened. So it looks like that Jeff Atkins, without anyone noting him, he could not, it's impossible for him to go to the desk of the docketing clerk asking to change the decision date. And it was changed back after I filed papers with the court. And 1 month later, during the Thanksgiving time, it was changed back to April 28, 2017. Throughout the petition, I never mentioned that June 8, 2017 to be the decision date. So this is someone behind that told Jeff Atkins. This proves the existence of conspiracy. And then if we go down to, let me see, November 17, 2017.
Okay, all right, right. Hold on. All right, here.
Right. So that is, this is regarding the defiling of the amicus curiae motion. If you scroll to the second page, that will be more clear.
Okay.
The second page. You can see that at the middle part of second page, this entry was altered on December 18, 2017. The December 9, 2017, it took about 2 weeks for the U.S. Clerk's office to docket entry of receipt of the amicus curiae motion of mothers of lost children. And then 10 days later, on December 18, 2017, they altered the docket to be this way.
Okay, wait. So on December 18th, they altered the docket to read like this?
To be not accepted. So that means they defile. They defile it.
Oh, I see what you're talking about right here.
It was defile, but
not accepted for filing.
Right.
And if you look up here on November 17th, motion to leave for to file amicus brief was here on the 17th. It takes them whatever amount of time. Gotcha.
17 until December 9, so that means 22 days. So they did not docket it took 22 days, but 22 days includes the mailing time, so it should be 20 days. So they waited 20 days to eventually docket it. If you scroll to page 3, would you please kindly scroll to page 3?
Yeah.
So if you take a look at page 3, that was printed on at the left upper corner. This docket was printed on December 18, 2017. And if you see the entry, December 9, it's accepted, it's filed. Amicus mothers of lost children, amicus brief of mothers of lost children, it was filed. And the file, the e-file was posted there. At that time, if you click at the bottom, a line lower than that, mothers for a motion for leave to to file.
Yes.
You will see the e-filing document, the complete document. You will see that. So this was altered. The same one, the same entry was altered. If you scroll back to page 2, you will see that now it's changed. It was changed, removed, altered to be not accepted for filing for December 9th. The same entry.
Okay, so let me go back here. So here it is. We're looking at December 18th, 2017. It clearly shows that amicus brief of mothers of lost children is submitted right here on December 9th. And then you go over here, December 9th, not accepted for filing. Now, I guess my question is, when they decide not to accept something for filing, don't they have to tell you a reason, like you didn't sign it, or it was past the due date or something?
No, no reason.
No, but I'm telling you, I mean, what I'm asking you is, normally when the courts do not accept a filing, they have to give you a reason. In this case, they don't give you a reason, right?
They just asked Chris Katzenbach attorney to refile. Later, they say we will defile because it was improperly filed.
Gotcha.
So they didn't say why was it not properly filed.
Right.
So we have to defile it, and well, they say, oh, you probably need to separate, with some very weird excuse, you need to separate the motion from the brief, and the motion contains only 1 page, and no one did that. No one did that throughout the practice of the law. It's always combined in one pleading, and they want to separate it, and there was no legal basis. So eventually they post again. It's identical document, and they post the document. They posted it, and then they corrected the December 9th entry to make it the correct date of the November 17th. But they did not. The clerks has a duty to post any activity of refiling. They didn't do it. So right now on this website, the U.S. Supreme Court, if you go into this case, if you click on the November 17, 2017 file, if you click open, you will see the file name was 2017-12-19. It was refiled on December 19. And it was under my threats while I sent an email to the clerk, Donald Baker, that this is a violation of the penal code. This is a crime. And you have no judicial immunity. And I gave him the case law that he just cannot do it. And then this was put back. Yep. So this shows the irregularity. Yeah. And if you see the page 2 right now, for February, now it's pending for hearing for tomorrow, February 2nd, 2018 petition for rehearing, and February 6th, 2018 request for recusal. It is not named a request for recusal. It's named renewed request for recusal, but they did not put renewed. And also the date, they should have put February the 2nd, 2018. But the supervising clerk, Jeff Atkins, who's in charge of this, he refused to put February 2nd, 2018. Supposedly, they were mailed simultaneously. Only one mail simultaneously. Mm-hmm. How come they put the 2 dates? It's very fishy. But they probably try to say, oh, it's not timely. You should file the same time. Probably that's their argument. But the clerk knowingly put on the wrong date. I sent objection to Jeff Atkins. He refused to correct. So Jeff Atkins apparently was someone directed him to do something on this docketing clerk, on this docketing of 17613, or otherwise this kind of irregularities never happened.
Right.
In the U.S. Supreme Court. It did happen frequently in my cases, in the underlying case, which include alteration of docket. So this make connection regarding the conflict of interest. I truly believe Jeff Atkins are directed by American Indian Court or by James McManis to do these things. His alteration of a docket in the beginning on October 25th, 2017 shows his connection with James McManis and Michael Reedy, who are very active attorneys and so-called leading attorneys of American Indian Court. And you may recall that my comments regarding Jeff Atkins allowing another of his colleague, supervising clerk Jordan Bickell, B-I-C-K-E-L-L, Jordan, J-O-R-D-A-N. He allowed him in September to step into Jeff Atkins' authority to bring a clerk named Donald Baker to disallow filing in 17-82. So disallowed the filing of amicus curiae motion of mothers of lost children. So that is to tell you their violation of First Amendment and 14th Amendment of the Constitution. The U.S. Clerk's Office violated Federal Rules of Civil Procedure Rule 5D4. They violated Federal Rules of Appellate Procedure Rule 45B1 and 3, which spells out the duty of the clerk to maintain the dockets and records. They violated the Federal Rules of Civil Procedure Rule 79, which required the clerk's office to keep the record of a civil docket. They failed to enter into the docket that December 2020. They put back this docket. They put back the American amicus curiae motion into this docket. They altered the docket on December 9. They failed to correctly docketing the receipt in the first place and delayed by 20 or 21 days. And docketing of December 9, 2017, and later changed on December 18, 2017. So this is the proof that God helped me to say. The page 3 I printed under the instruction of God, and then within an hour it was changed. So it was within an hour, December 18, 2017, when I printed it, the third page, the docket changed for the entry of December 9, 2017. This is irregular and violation of their duty, and this constitutes a conspiracy to disrupt the basic function of the U.S. Clerk's Office, which violates 18 U.S.C. Section 371 and justify impeachment of Jeff Atkins. Thank you.
All right. Well, this is very interesting. It's just amazing the amount of evidence that you have. Now, let me ask you this, Linda. Is this something that the FBI would get involved with? Who would be the enforcement, the legal enforcement arm that would get involved in something like this?
That should be U.S. Department of Justice as well as FBI, yes. And regarding impeachment, that will be the U.S. House of Representatives. So I truly hope the audience can encourage their representative in the area to issue article of impeachment to impeach Jeff Atkins, impeach Jordan Bickell, and impeach the 8 justices. The Chief Justice of the United States have a statutory duty to oversee the correct function of the clerk's office.
Gotcha. All right. So the FBI would look into something like this where maybe somebody is disrupting justice or meddling with court services or processes. So Linda, what happens if Friday I guess there's a couple of options. They could the motion could be what's it called? Could be you could be awarded the motion, right? So you could prevail. Then of course they could what do you call it? They could, I guess, deny the motion, so it would be against you. Or the third thing is they could postpone it. Is that correct? Are they able to postpone it?
Yes, they can. They can continue. They can continue the conferences.
Okay. So if they, let's say, obviously if they postpone it, then we have to wait again. But what if they rule against your motion? Then what happens? What are your alternatives? What are your choices if they rule against you?
With their present corruption, I cannot do anything other than, but I have ongoing other cases going on right now. So there will be additional petitions to be filed with the court going on. Right now, for example, there's one case in the Ninth Circuit case, that's a civil rights case, that will go to U.S. Supreme Court, and this same issue will be repeatedly brought to the court again. But right now is the biggest problem. What is whether these justices should be impeached when they fail to recuse. They fail to recuse, but went ahead to deny to participate in the decision of the substantive issues will cause the complete mess up of the entire United States judiciary. So the fundamental justice for the U.S. people is we need to have a fair court. Everyone must have the right to have an impartial court. And so the disqualification of the judges, very common, and now it's disrupted by the leading justices in the Supreme Court. Right. And what kind of mess they will cause is that now, because of their bad example, that every judge right now throughout the United States, they can say, we don't have to decide on this disqualification issue. We will just deny whosoever are against us. Whosoever we don't like, we can just go ahead and deny. We don't have to disqualify or recuse anymore. So this caused them to be a good ground for impeachment.
Sure. So if these justices actually get impeached, then what happens to your case? Who would hear your case? Would new judges then step in?
Well, if they are impeached, then my case will automatically be reversed because
that makes sense.
Yes.
Okay.
But their impeachment to remove these justices will clear up the air of the judiciary of the United States to give back the clean air of the judiciary.
Gotcha. Linda, we're out of time. I'm excited to catch up with you Friday and see what happens. I want to wish you the best of luck Friday. I hope that God will bless you and that justice will really prevail in your favor. Linda, I want to thank you so much for stopping by today and sharing.
Thank you very much for your time. Thank you, everyone, for listening.
You bet. And guys, if you want to follow along, if you want to follow Linda's story, you can go to SHAO chronology.blogspot.com. Again, everybody, thank you so much. Let's share this message. Let's get as much attention as we can to Linda's case. If you are a single mother and you've seen some of these struggles that Linda's talking about, reach out to Linda for support. Give her your love and your support. Maybe reach out to Meera Fox and to the Mothers of Lost Children and see what you can do to get involved. Everybody, thank you so much for stopping by today.
Thank you.